Everybody to this session of the online lecture series on rule of law and democracy, organized by Dr. Sofie Møller and Carlos Gálvez Bermúdez at the Research Center Normative Orders. Today, we have the honor of having Professor Seana Shiffrin presenting her lecture, Democratic Law. Thanks for being here with us, Professor Shiffrin. And Carlos Gálvez Bermúdez will comment her presentation. Unfortunately, Professor Hesselink cannot join us today for health reasons, so we wish him a fast recovery. So Professor Seana Shiffrin is Professor of Philosophy and Pete Cameron Professor of Law and Social Justice at UCLA, where she has taught since 1992. She teaches courses on moral and political philosophy, as well as contracts, freedom of speech, constitutional rights and individual autonomy, remedies and legal theory. She served for 16 years as an associate editor of Philosophy and Public Affairs and serves as co-director of the UCLA Law and Philosophy program. She's a member of the American Academy of Arts and Sciences. In 2016, she received the UCLA School of Law Reuter Award for Excellence in Teaching. Her research addresses issues in moral, political, and legal philosophy, as well as matters of legal doctrine that concerns equality, autonomy, and the social conditions for their realization. She has written extensively on the morality of promising and the role of law in facilitating and fostering moral character, with a special emphasis on the connection between contracts and promises. Among her publications, we need to mention Speech Matters, Lying, Morality and the Law, published by Princeton University Press in 2014. The Norton Introduction to Philosophy, published by Norton and Company, 2015, and her most recent book, Democratic Law, published by Oxford University Press in 2021. So please go ahead, Professor.
Well, hi, thank you so much for having me. I'm really grateful to be here. And thank you for your patience with me. I'm afraid that I'm also a little under the weather. And I know that we're kind of an intimate gathering, but I'm going to still present a lecture. And what I'm going to present is a truncated version of the first chapter of my book, Democratic Law, which concerns the theory of the relationship between democracy and law. And the other two chapters are applications of that theory, one for contract law and one for the constitutional law of the United States. But I'll just start with a theoretical overview. So, law and democracy seem oddly estranged in philosophical discourse. Aside from some controversies about constitutionalism, there is at best only passing mention of democracy in most Anglo contemporary analytic jurisprudential treatments. Likewise, one can leaf through extensive discussions of democracy that do not elaborate any distinctive essential role that law plays in achieving democratic aims. Law tends to be treated as an instrumental afterthought. This self-imposed relegation of law and democracy to different intellectual compartments of inquiry deserves us by encouraging simplistic instrumental views of law and democracy as institutional devices that control untrustworthy agents or referee between warring interest groups that manage suboptimal circumstances. And it's certainly true that law and democracy perform these functions, but the blinkered emphasis on them deprives us of articulate insight about why law and democracy are morally powerful and inspiring human achievements. And when we lose sight of our aspirations for these institutions, we begin to ask them to do less than they can, which sets us on a path toward apathy, cynicism, and decline. I suspect that the academic estrangement between democracy and law bears a complex relationship to 5 positions that I resist. First, positivist temptations to think that the most significant features of law must hold true within decidedly non-democratic states like Saudi Arabia. Second, a latent mistrust for law contained within some conceptions of law as essentially coercive. Third, outcome-oriented conceptions of morality that denigrate the significance of motive. Fourth, malaise about whether democracy's intrinsic value can be defended. And fifth, an overemphasis on democracy's role in non-ideal theory. With respect to the last, many important democratic theories portray democracy's role as exclusively an instrument to install material and intellectual forms of justice, to temper injustice, or to provide a kind of at least we all had a say legitimacy to how we bumble along given our inevitable failures in achieving justice. And these are partly insightful accounts, but they're also incomplete. They fail to capture the full aspirations of law and democracy, aspirations that are part of the constitutive conditions of realized justice, and not only the fair conditions of approximating justice in non-ideal conditions. My constructive aim in response to these 5 tendencies I resist is to sketch a distinctive account of democracy's intrinsic value that non-accidentally highlights the virtues that law can uniquely display within democratic circumstances, whether ideal or non-ideal. To vindicate my claim that law and democracy enjoy an intimate relationship, I'll offer an account of democracy's intrinsic communicative value and law's special constitutive role in that communicative endeavor through which we represent our institutional collective expression of justice and other forms of collective morality. To define some terms, by democracy, I mean roughly a political system that treats all its members with equal concern, regards their lives as of equal importance, and treats all competent members of the community as by right and by conception the equal and exclusive co-authors of and co-contributors to the system, its rules, its actions, its directives, its communications, and its other outputs. In a healthy democracy, members have regular opportunities to exercise these rights and do so with some frequency. I'll highlight 2 preliminary points about the institutions that constitute a democratic system. The first, my rough characterization lends little support to the view that elections in particular are the defining characteristic of democracy. A free speech regime, including the legal right to petition government, to expect consideration and a reasoned response, as well as a vibrant free speech culture, are equally essential components. Without the ability to discuss, debate, and understand issues and people with others, elections have little purpose, whether as exercises of deliberate communication, self-determination, or efforts at preference satisfaction. Indeed, because elections are framed with determinate boundaries, whereas a free speech culture is free-ranging with indeterminate boundaries, a free speech culture is arguably more foundational to democracy than any particular mechanism of decision formation, including elections of representatives, which inevitably consolidate many disparate issues into one decision at a particular time. Whereas a free speech culture enables reasoned but focused discussion and feedback about singular issues at no time in particular. This temporal and substantive dispersal permits more targeted forms of discussion on specific issues as they arise and evolve. I mention these points only as a corrective to the fixation on elections as the sine qua non of democracy. To be sure, a free speech regime without elections and other methods for citizens to contribute to deliberations would also be severely impoverished. Second, although elections and referenda serve as important anchoring mechanisms of influence and political formation by citizens, we should not regard other elements of a political system, including judicial, administrative, or custom-based authority, as anti-democratic or somehow intrinsically lesser from a democratic point of view. If democracy is a system for the joint specification, communication, and implementation of mandatory and discretionary values, then whether we are communicating to deliberate, to report, or to commit, the appropriate mode of communication may vary, depending on what value is at issue, to whom we're communicating, and the requisite level of specificity. A group of co-authors may reasonably divide labor and delegate one or more of their members to listen and to speak for them in certain fora without sacrificing or compromising their equal status as co-authors. As many of us know from happy experience, an egalitarian co-author relation usually involves a division of labor in which each party brings their special talents and insights to bear on producing a joint message. One co-author may take the lead and speak for the group. The relation may remain egalitarian so long as each author retains the ability at a fundamental level to contribute and exercise decision-making authority, as long as each co-author retains equal responsibility for the collective endeavor, and those co-authors who take the lead still attempt to account for the contributions of all authors, not predominantly their own. As for law, I'll allow my use of it to emerge through a discussion of its democratic virtues and functions, but I'll make two brief points to start. The first is that although I conceive of law as public, as having publicly accessible, even if incomplete and partly inchoate contents, and as having temporal duration, I do not privilege statutes over judicial or administrative decisions, nor the textual ingredients of law over its other ingredients. And second, I sometimes use the term law to refer to discrete legal principles, doctrines, or decisions that have general application and, where applicable, have precedential effect, or another form of presumptive duration. But sometimes I refer to law as a legal system composed of such public principles, doctrines, or decisions, a system that aims for and substantially achieves justificatory cohesion. And so by democratic law, I mean a legal system, the content and generation of which merits its characterization as democratic. My thesis is that for their realization, some of our mandatory moral ends require democratic law generally, as well as the democratic generation of some particular laws. The democratic generation of law is not, as many prominent theories would have it, a mere means to achieve just conditions that can be identified without reference to their provenance. Nor is it merely the fairest method of resolving conflict. Democratic law is not merely a means to or complement of just material, social, and intellectual conditions that are independently specifiable. Democratic law is a constituent condition of the full realization of justice. So my defense of this view begins with a problem for which democratic law is the solution. The problem is not the familiar one of how to justify coercion, a problem that unduly fascinates many democratic theorists. The problem that interests me arises prior to disagreement, dissension, threats, and the prospect of disobedience. Even in a largely just society full of citizens of goodwill, each of us in communal living would face significant communicative challenges of a moral nature. Democracy may uniquely address these challenges through democratic law. The forthcoming argument that describes an exemplary challenge and the ingredients for a solution has four major steps, positing first some moral requirements for citizens to communicate with and to each other. Second, the importance of direct and at least partly articulate communication for certain messages. Third, the role that actions and commitments play in effective, sincere communication of some morally important messages. And fourth, the unique role democratic law serves in communicating those messages. So I'll begin in order with the moral imperative of communication among citizens. Start with the assumptions that first, we are all moral equals, and second, that our status, our perception of our status, and our mutual recognition of our status and the needs and interests that accompany it influence our sense of self-respect. That is, I agree that Rawls is roughly correct that the social bases of self-respect are a crucial component of the conditions for maintaining one's self-respect. This maintenance, in turn, is an essential component of our mutual flourishing. So as a just citizen living in community with others, I should be interested in contributing to and receiving the social bases of self-respect. But as an individual, I confront the difficulty that the social bases of self-respect are not merely material in nature, but are communicative. It matters that we manifest our mutual respect, and not merely that we coexist in circumstances that give everyone access to the basic minimum, that no one sets fire to the central distribution depot, that we pay taxes, and that civil rights are not violated. A just allocation of material resources is compatible with mutual indifference, grudging accommodation, or even mutual contempt, should the penalties for destructive behavior be severe enough to nevertheless induce patterns of obedience. It's important that we underwrite the social bases of self-respect, both through what I'm calling the material and intellectual forms of justice, meaning that we ensure that people are afforded the opportunities, goods, rights, and services they are due, and also through communicative means, conveying that these provisions stem from our non-grudging recognition of each other as equal co-members of our political society. Our communicative challenge is compounded by the fact that in our daily lives, it's nearly inevitable that we will send mixed signals about our commitments. As just agents, we may be committed to the equal moral value of our lives and our equal entitlement to secure membership in a society of equals, irrespective of our distinctive individual features, including our race, gender, ethnicity, orientation, beliefs, and affiliations. But these commitments cannot regularly be read off the patterns of our daily behaviors, the content of which is often driven by partial commitments to family, to smaller communities and affiliations, and to associations with strong substantive commitments. The personal value of each of our lives, in large part, derives from our immersion and dedication in these particular partial activities. This immersion may create the understandable impression, however hazy, that affiliations do matter for our social and political status. And moreover, our immersion in them may create the hazard that we will start, however unconsciously, to associate substantive commonalities with the indices of moral and membership status. To counteract these hazards, we need to convey our mutual recognition of each other's moral and membership status and our intentional, deliberate implementation of the commitments that flow from it, to ensure that our recognition is communicated, to counteract any inadvertent suggestions to the contrary, and to remind ourselves of the limits of the significance of our substantive affiliations. Insofar as we act as lone individuals, communicating respect to every other citizen is difficult. There are the patterns of life I've described, but time constraints also prevent us from reading the essays and ads and tweets of all of our fellow citizens. And my words as a lone individual, absent a collective method of representation, will represent me as a private person, but not the collective. But part of my moral imperative is to belong to a collective that communicates to its members their inclusion as equal members. I need to communicate as a citizen, not only as a private person. Moreover, a merely discursive affirmation that one's fellows are moral equals deserving of just treatment would not suffice to convey this commitment convincingly. It's not simply that words alone may be received as rationalizing bromides given our more partial patterns of action. The reason why our partial actions may overshadow our discursive affirmations and render them mere platitudes is that some moral beliefs, attitudes, and stances, if they're fully appreciated by those who hold them, dictate appropriately motivated action. Hence, to an observer, and particularly to the putative object of these beliefs, attitudes, and stances, the absence of relevant action by me and by us may reasonably suggest a failure of full and sincere affirmation. It's not enough for me to endorse a pattern of installed justice, because discursive affirmation or endorsement of a system may be issued from a posture of remove that will not succeed as a communication of respect, which is an interpersonal relationship requiring more substantive participation by its members than mere approval of one party's circumstances or another's actions. For example, I, as a US citizen, may endorse the general approach Sweden takes to economic production and distribution as a rough approximation of what economic justice demands. But in doing so, I don't convey my part in a relation of mutual respect toward the denizens of Sweden because I'm not a Swede, and my endorsement plays no internal role in generating these relations. In other words, discursive affirmation of a moral proposition and appropriate conforming action, when considered or rendered separately, may each be insufficient to communicate the appropriate level of commitment to that proposition. They must be rendered together as a legibly interconnected pair for either component to realize fully its role in the communicative expression of the moral proposition's endorsement. And this idea is not unfamiliar to moral life. Action with a particular content and structure, motivated in a particular and transparent way, may be necessary for some moral beliefs and attitudes to be successfully communicated and received as sincere. So, I've described 4 structural problems in satisfying the political imperative to convey respect that may be summarized as follows. First, we cannot convey our mutual respect to one another as equal members on an individual basis, given what, in this context, sincere and effective communication of a collective commitment would require. Second, much of our behavior is communicatively ambiguous. Our valuable relations of partiality are often open to interpretations in tension with a stance of mutual respect. Further, mere compliance with just institutions is compatible with an absence of mutual respect and recognition. Third, mere endorsement, whether vocal or mental, of the elements of a just basic structure is insufficient to discharge our communicative obligation. And fourth, there's the risk that our valuable relations of partiality will dominate and transgress their normative limits if they're not tempered by activities that generate, convey, and reinforce our commitments to impartiality. And my contention is that democracy and democratic law play unique roles in addressing these problems. Each of us needs to perform and receive a form of communicative action that enacts and thereby expresses our commitment to the respectful treatment each of us merits. But even if endorsed by each of us individually in our hearts and editorials, a system of civil and economic rights that satisfied the substantive requirements of justice would fail to satisfy the communicative need. The system, therefore, must not only be endorsed by us, but it must also be our product. Its production must have a communicative component to it, one that could be publicly grasped. So other things equal, each of us must be involved in the generation and maintenance of this otherwise just system for its creation to be our product and for each of us to fulfill our communicative duties through it. The involvement must take a democratic, egalitarian form because each of us must have the opportunity to participate for the communication to be publicly manifest as each of ours. And law plays a special role in fulfilling this communicative mission because it has an expressive dimension that, when democratically forged, represents our motive, and because it involves a temporally extended commitment to action. Law has the capacity to communicate our collective stance and at least one embodiment of our collective motive, while also achieving substantive normative results. Were we just to perform what justice otherwise requires of us without declaring our commitment through law, in a sense, we would perform the right actions and we might act from respect, but we would fail to do so clearly under the banner of a self-assumed joint public commitment. But some actions, especially those implicating fundamental status, require deliberately communicated motivation of a particular kind from the proper recognition of the relevant reasons. Of course, it can be better for the conforming action to be taken without an accompanying clear message of recognition and commitment than for no action to be taken. Take the familiar friend who always denies error and does you a wrong. When confronted, she denies the error, but subtly alters her conduct and engages in small kindnesses that work some compensatory repair. Sometimes such gestures, action without proper recognition, are a sufficient form of communication. But in other cases, something more articulate may be required, like when the transgression is substantial or a repeat offense, when the denial is outrageous, or the principle at stake is fundamental. A behavioral change matters, as does the material offering, but the friendship may not be fully repaired without the more articulate recognition of the relevant principle, the shortcoming, and their articulation as part of a commonly understood history and commitment going forward. Similarly, even if we were to vote day by day to endorse and enable these performances in a thorough exercise of direct democracy, we would not be undertaking a commitment to which recipients could point to as publicly common ground. It's true that certain overtures and some deliberate patterns of behavior directed at others may themselves generate reasonable forms of reliance. But at best, such overtures only indirectly and ambiguously convey a commitment to a substantive expression of respect with longevity. They therefore ambiguate between a commitment and a more temporary grant supplemented by a perpetual reauthorization process. Patterns of beneficence without the backing of commitment do not empower beneficiaries to make appeals and demands to the prospect of continued performance. Whereas by generating public commitments through law, we demonstrate our endorsement of the system of justice, so much that we choose to commit to it in a public way that typically carries a substantial degree of longevity. As with promises, public commitments through law deliberately alter the normative status of recipients and provide them with a common reference point on which to base expectations and form entitlements to call upon our adherence. Other expressive theories of law have focused predominantly on the negative expressive potential of law, to oppress, to marginalize, to disparage, or to discriminate expressively. But they neglect what I've been emphasizing, namely the positive communicative capacity of law. I think this difference in emphasis may trace to the fact that many expressive theories work, often implicitly, with a non-democratic model, in which the government or state as speaker is treated as distinct and separate from its audience, whereas a democratic legal approach understands government speech as ultimately ours. If law embodies our speech to ourselves, then when its communicative content subordinates or disparages a portion of our community, we are implicated and not only entitled to a horrified reaction from the sidelines. But at the same time, because democratic law is ours, we are thereby enabled to perform our communicative duties through it. So now I'll turn to discuss what law adds to a well-ordered culture. Because of course, even absent public official commitments, citizens can and have to call upon each other to fulfill their duties of justice in extra-legal contexts. In part, we have to do this to persuade each other, to draw attention to our needs and failures and aspirations, and to ensure that we generate more explicit official forms of legal recognition where appropriate. But even in ideal circumstances, the ability to refer to democratic law has special moral force, even when its content is coextensive with what justice already demands and with what citizens already privately say to each other. In many cases, democratic law renders determinate how principles of justice should apply in a particular context. Justice may demand fair equality of opportunity, and citizens could affirm that demand to each other in their daily lives, in classrooms, in the workplace, and they could do their best as individuals to conform to that ideal's requirements. But the law may, in response to specific needs and threats encountered in a relevant environment, render significantly more concrete how that requirement will be understood and implemented. And thereby the law gives specific shape and coordination to the direction of our actions and the content of our expectations. Concretizing a partly indeterminate obligation figures among the standard functions of democratic law and is crucial to the generation of a particular polity's distinctive identity. But it may be worth thinking about the maybe hypothetical case where the law is fully redundant of the requirement of justice, adding no detail or specific content. For instance, some may think this characterization holds of the US First Amendment's commitment that the state will make no law respecting an establishment of religion or prohibiting the free exercise thereof. Even if redundant, its articulation has distinctive communicative moral resonance because it conveys to everyone that we as a community know we have this duty, we know it's relevant to our situation, we aim to convey our knowledge of this duty to each other as fellow duty holders and claimants. Putting it into words, putting it into our own words, conveys sincerity and a sense that this moral commitment is sufficiently important to make salient. This acknowledgement is a central moral good for the recipient and may supply reliance. This point is a familiar one in criminal procedure circles. Officers should recite the Miranda warnings, which are the US warnings of the rights of arrested people. Police officers should recite these to their arrested peers, to lawyers, and to repeat offenders, even when the recipients obviously already know their rights. Recitation of warnings to the knowledgeable conveys that the reciting officer knows the rights, acknowledges them to the party those rights protect, and thereby conveys a commitment to respect them. Articulation is not only important to the recipient, but also to the duty holder who articulates it. Public articulation forges a personal connection to the duty in a way that silent acknowledgement does not, which reinforces the duty's role as an organizing moral principle for the speaker. And finally, articulation alters the moral dynamics between speaker and listener. When a duty holder conveys her acknowledgement and affirmation to the person to whom it's owed, she acknowledges that that beneficiary has a stake in her performance and in being assured. And by establishing the duty as common ground between them, she invites the beneficiary's perspective on the performance. This invitation enhances the meaningfulness of the communication and alters the moral posture of the claimant. When I ask you to perform your unacknowledged duty, the dynamic is likely to be one of demand or chiding or moral education. Our moral posture structurally tends toward the hierarchical or the adversarial. By contrast, when I ask you to perform a duty you've publicly affirmed, the dynamic is more cooperative. I'm reminding you of something you've affiliated yourself with that's publicly connected to your identity and integrity. We can understand my reminder as a partial effort at joint collaboration in working out how and when to advance something of mutual and shared concern. Even when we have conflicting interpretations, our discussion will tend to center more on what we mean and value about disestablishmentarianism, for example, rather than on whether religion or atheism are bunk. So what I've just been arguing is that even were the moral and intellectual components of justice already in place, each individual would have a need for an organized social form that affords each person the opportunity to participate in a collective endeavor alongside others directed at her fellow citizens. And she equally has a need to receive that communicative output. The assumption of realized justice is not a plausible approximation of our circumstances, however. It's just meant to highlight that the value of democratic law is not fully captured by an instrumental role in obtaining the results of material and intellectual justice. But of course, in our circumstances, the material and intellectual components of justice don't come to us prepackaged and pre-installed. And consequently, our individual obligations of justice are not confined merely to taking ownership of an existing system of justice in a communicatively resonant way. Our obligations are to ensure the components of justice are crafted and realized in a communicatively resonant way as ours. As with the communicative burdens with which I began, our individual obligations of material and intellectual justice could not be discharged through individual uncoordinated action. But they can be achieved collectively through an organization to which we all belong and contribute that manifests equality in its explicit structure, its processes of creation and implementation, and the consequences of its output. Each of us alone cannot show our recognition of each other's mutual equal status and belonging through interpersonal everyday conduct, but our legal system can do this. It can adopt explicit laws that declare and support our equal status and needs. Its laws can aim to create environments in which individuals interact with one another on an equal basis, including avenues of access to power, and its own internal procedures of generation, implementation, and enforcement can reflect this fundamental recognition. These processes and outputs themselves then serve as our collective expression to ourselves, so long as their generation arises from processes that pay tribute to our mutual equality. And the state is the crucial organizational structure to achieve these communicative aims. Families and voluntary associations cannot achieve their values while paying full tribute to the value of inclusion. Families can't achieve intimacy while embracing a stance of terrific inclusiveness. To achieve the substantive affiliative values and purposes of voluntary associations, they must have the ability to exclude on the basis of perceived fit and congeniality, as well as on the basis of substantive dissonance. And these values cannot be achieved by a group that is fully inclusive of everyone in virtue of a common substantive feature or aim, like our each being a child of God. For while the all-inclusive association may insist on our common possession of the feature, an individual may disavow its possession or importance, and so the association will fail to convey the appropriate message of inclusion. To convey our endorsement of the value of belonging, we need an organization that has the qualities and resources necessary to be a site of unselective inclusion, namely one that has control over geographical space and sufficient resources to ensure its members can be afforded access to them that will allow them to function effectively within its space as an equal member. And the democratic state has the unique ability to convey this mutual recognition that's connected to its unique ability to respect and address a related fundamental moral fact, namely that we each as social beings have a legitimate need to have a home, among others, a place to which we belong and in which our other needs have standing, just in light of our status as humans. And so this legitimate need places pressure on all of us to resist qualification-based citizenship and immigration policies, and to favor those policies that use automatic, random, or need-based criteria. Fulfilling these two interconnected missions, first, expressing through action the recognition of our mutual equality as free persons, and second, the complementary recognition of our legitimate claim of inclusion and membership in a collective moral body, are the fundamental charges of the state that are achieved in their most meaningful form through laws crafted within a democratic setting, in which we each have participatory powers in the construction of law and the mode and direction of its implementation. Such participatory powers allow the state's expressive actions to be reasonably attributed to its citizens. Two features of democratic law do work here. First, the law affects a persistent institutional commitment applicable to all. And second, in a democratic structure, law has a communicative dimension whose content can be attributed to all of us together. This account offers reasons why one should participate in democratic processes, even when predictably your preferred position would win without your support or lose even with it. And it offers reasons to adhere to law, and it supplies a connection between participation and adherence. My reason to vote is not exhausted by my interest in influencing the election's outcome. It's provided by the imperatives that I should express my affiliation with a joint collective body that has the function of embodying our commitment to equal status. I, as a co-author, should contribute to the joint deliberation and determination of the particular form that commitment should take. Similarly, my reasons to adhere to law include the communicative recognition that democratic law is an ongoing effort to express our mutual respect. By adhering to law, I express my affiliation with an ongoing effort in that joint affirmation, even when I would favor expressing our joint mutual respect in very different terms. Protest and other visible vocal means of dissent work alongside voting and adherence. Separate from any hope of sparking repeal or future reform, these activities add nuance and complexify the message conveyed by an election or the passage of a law. The symbiotic complementarity of participation in elections following the law and vocal protest underscores my earlier contention that a free speech culture is as essential to democracy as elections and other representative devices. And finally, I'll note that a communicative account also offers distinct reasons for a Dworkinian, morally tethered approach to legal interpretation, but one that's divorced from Dworkin's concern about legitimizing law's coercive power. On a communicative view, if an essential function of democracy is to convey jointly to each other our respect for our mutual equality and our commitment to justice and other moral aims, then the principle of interpretive charity recommends that democratic legal materials should be interpreted in light of this aim. And second, a judge herself, as a citizen who represents the collective, has reason to contribute to the moral communicative process of which law is a component by infusing her legal decisions with appropriate moral content. A judge should be sensitive to precedent and continuity with the past, what Dworkin labels fit, in order to realize our interest in expressing ourselves when called for with a constancy that contributes to the steadiness of our commitments and the coherence of our distinctive voice as a community over time. And finally, to the extent that fit roughly serves the values of horizontal equity, albeit intertemporally, sensitivity to fit also institutionally manifests our commitment to equality. So to conclude, I've been arguing that a system of democratic law is an essential mechanism through which the community's members express to each other their joint recognition of each other's membership, their belonging by right, and their equal status substantively understood. I think this argument provides a basis to reject the widespread sense that democracy has no intrinsic value. And it may also revive some interest in the law by democratic theorists and perhaps encourage the idea that the role and function of law in a democracy differs substantially from its role in unjust systems. And finally, such a theory lends itself to a more positive and inspirational view of law, democracy, and their aspirations than those current views that cast law and democracy as methods of controlled skirmish between opposed interest groups. Effective communication of a deliberate, sincere motive of inclusion in a society of equals through articulate and practical means is a cause. Its achievement is a moral accomplishment. On some views of morality, successful efforts at moral agency represent the realization, or at least the pinnacle of freedom. The moral and expressive collective opportunities that democracies afford should explain the passion for democracy as a realization, or at least the pinnacle of collective freedom. Thank you.
Well, now then we are going to have the comment of Carlos Gálvez Bermúdez. And after that, we are going to make a break, take a break of 10 minutes. So Carlos Gálvez Bermúdez holds an LLB from Rosario University in Colombia and an LLM in legal theory from Frankfurt University, where he worked under the supervision of Professor Klaus Günther and Professor John Gardner. Before his current position, he has a law clerk at the Colombia Supreme Court, and he was a legal intern at the Inter-American Court of Human Rights in Costa Rica. Carlos is currently a doctoral candidate in legal philosophy at Frankfurt University, a doctoral researcher at the Research Center on Normative Orders, and a tutor at the LLM of the European Academy of Legal Theory. His research focuses on the intersection of philosophy of law and democratic theory, and currently works on theories of practical reason and reasons for action, authority of law, and democratic legitimacy. So, Carlos, please go ahead. You have around 10 minutes for your comment.
Okay, thank you very much, Emilia. And thank you very much, Professor Shiffrin, for this presentation. I would like to make a short comment. I have many points here, but I will try just to touch a couple, and then depending on how much time I have, then probably we'll leave it for the discussion, if it is okay for all of you. I want to start first. I have to admit that it was difficult to prepare a comment to this talk, especially because I attempt to agree with many of the points that were presented. So, but there are some points that I would like to ask, or some that I would like to suggest a different answer than the one that Professor Shiffrin has offered. The first point that is more a question rather than a comment on that is, I want to know more after hearing all of this presentation. I want to know more how far this model can get in general jurisprudence understanding. We know much about the moral role that law plays in democracy, the role in reinforcing the moral status as equal agents and of expressing our forms of collective morality, thanks to the presentation of Professor Shiffrin. But I would like to explore if democracy also plays a role in understanding law as such. How far law and general jurisprudence need democracy to understand their general futures, the futures of law as such? It seems to me okay, like let's call this democratic jurisprudence as general jurisprudence. It seems to me that in your work, you not just build democratic law, but you also bring a new proposal of general categories as such. You not just transform the understanding of punishments and coercion, but you also transform the ideas of authority, of compliance to reasons, and the role of reasons for attitudes in order to achieve legal normativity. If law wants to do what it claims to do, it seems to me that it has to be claimed as ours. And with these explanations, the law is ours. After the presentation, it looks like it gives also an answer to the categories as such, and not just for the concrete democratic law, if it is taken that law exists without democracy. My first point is that I want to know how far you see that your model can arrive, and how far is your attack to legal positivism in general. My second point, please, Emilia, tell me when the 10 minutes finish, because I forgot to check what time I start. My second point is more about the communicative and expressive function that you attribute to law. It seems to me that there is also another interpretation that could works for me probably in better terms to a democratic project. That is that communication is not just an expressive function, but it's also a transformative and a constructive process. It has a transformative and a constructive role of the, these communicative means have also a transformative and a constructive role. Then transformation from, then it will be a transformation from equal status through political institutionalized process that will make a difference in the status and in the outcome it has achieved. In that sense, it is not just that achieves the value that anyway should has in the community, but also that it has transformed a moral duty to a legal duty through the political process. The same with the status. The political process has allowed that the moral status is transformed into a legal status where the agent is not just equal among each other, but also where they are responsible. The rights are not being thought just in this moral sense, but thanks to all of this communicative process in the constructive way, it has been transformed, and you are constructing new rights, new duties, different than the one that you will have without all of these processes. So it seems to me that it's not just to promote and reinforce moral relations, but also to transform and create new ones that allows them to make claims in a different level. Then public articulation, then this idea of public articulation will be understood in a different way if you take this constructive understanding I'm suggesting. We don't just execute our moral duties through law, but we continuously transform and create them in a way that is impossible to achieve in an individual sphere. Then law allows us to create different and duties in a collective environment that everybody will need to respect. That brings me to the idea that if this is correct and plausible, we are not recognizing our status. We are taking our moral status as a starting point, and through the political and legal processes, we are constructing other status, like the moral, like the political and the legal ones. Then law is not just to pursue a moral agency, but to construct a legal agency. That's my second point. How much time I have?
You have 3 or 4 minutes more, but don't worry.
I can put one more. I have many because it was so interesting, the book and the presentation. So my third one, I will make it really short, is I want to know why, if with this alternative reading that I'm suggesting, a constructive reading that take communication as a constructive process and not communication as a recognition or a process, I want to know why much emphasis in equality and not in something more active, having Rainer here, something like reciprocity. When you are talking about gratitude in the book, I thought you were going to take that away. But then equality get a central role because this recognition of a moral status is the central point, and law, if I understand well in your proposal, law is a way to execute these moral duties. But could not be possible to take this other understanding, to think that reciprocity plays a better role, and then if reciprocity plays a better role, perhaps this constructive process also could perform the same role that you are suggesting in your communicative recognitional theory? Okay, I think these are the first points, and then we can continue. Thank you for the time, and thank you for listening to me.
Thank you very much, Carlos. So now we are going to do a break, take a break of 10 minutes. Let's say we come back at 7:10, 10 minutes past 7, and we continue with Professor Shiffrin replies to Carlos. Is that okay for all of you?
But perhaps we can already move on to Professor Shiffrin's comments, and then Amelia will be back for the...
Oh, well, terrific. Carlos, thank you so much for these terrific and ambitious topics for discussion. I think I'll try to be brief and just say a little bit about how I think about them. Your first question was, I think, whether my account of democratic law contains within it a larger theory of law or criticism of positivism. And I'll just say the following, that to the extent that law is not crafted in democratic circumstances and does not express justice, it's clearly defective. And it seems as though those who subscribe to a different view of law would have to explain what the point of non-democratic law is and what its defense could possibly be. But on my own view, it suggests that other things that have some legal form but are not crafted in democratic circumstances to express and instantiate our collective moral commitments have not fully achieved the potential of law. They're like defective moral actions that have some of the form of a moral action, but either have the improper motive or the improper aim or target. That may be what you have in mind in asking whether this has implications for other views of law, but that's sort of the position that I take. Because I don't really see a distinction of an important kind between morality and law, I don't really have the language or the vocabulary to say that other forms of law are legally defective insofar as that's distinct from their being morally defective. The function I see of law is as a form of moral realization and expression. So to the extent that non-democratic law fails either in its procedures or in its target, then it's just a defective form of action. So your second question was about the way in which law, or your second set of points was about the way in which law can be transformative and constructive. And I think that I am entirely in agreement with you But maybe I'll put the points in my way to see whether or not we really agree. So it seems to me that if we take the example of cases where we acknowledge that people have rights, but that they are being frustrated or not recognized, that there's a difference between knowing that they have a right and recognizing that they have a right in practice. And that recognition in practice makes an enormous difference to their actual relations with people. So we may say that we have a right to free speech that's not being acknowledged or respected, and others may endorse that position. But the endorsement itself bears a striking kind of pale relation to the actual recognition of that right and the various actions and relationships that are possible once legal recognition is in place. So that's one way in which there's a transformative difference associated with recognition that I talk about a little bit in the first chapter, of the ability to be seen, to make demands, to make entitlements, and actually put a right into practice. But the second larger point that I think I agree with you about is that, of course, the concretization of a moral duty in practice will always make a difference to its content because the concretization involves our own creative and sincere interpretation. And so what I think I want to say is that almost every moral duty has a certain amount of indeterminacy about how exactly it will be expressed and realized. And that an important aspect of action in the individual case and legal and social behavior in the collective case is that we express our interpretation as a distinctive body. And we express a distinctive interpretation in light of the particular individuals who will be its beneficiaries and objects, so that there's always a creative dimension to expression. Indeed, there has to be, for it to be sincere. What sincerity involves is the articulation in our own words of a certain commitment. And through this sincere articulation, various forms of difference will arise. It's what I think makes for the difference between separate political polities that may be all committed to the same abstract principles of justice, but their concrete realization will take different forms, which gives each polity a distinct character, which in turn is part of what makes for strong feelings of affiliation, which in turn may motivate participation. So I think that this element of transformation and sincere creative expression is extraordinarily important in all forms of moral action, individual and collective. And then your final question is, why do I focus on equality and not other significant values like reciprocity? And I'll just say that I take the example of equality and self-respect as an exemplar of the kind of challenge that I think we face. So a kind of moral value that requires communication. I'm not hostile to the idea that there are other such moral values. I tend to think that reciprocity and equality are essentially committed to one another, but I can imagine making a very similar argument through the route of reciprocity. So I'll stop there.